Kedarnath Singh versus State of Bihar, 1962. Freedom of speech and expression is a fundamental right under Article 19 of the Indian Constitution. However, does this right include the right to criticize the government of India? If somebody criticizes the government of India, can he or she be booked under the law of sedition in India's Section 124A of the Indian Penal Code? Are Section 124A and Section 505 of IPC constitutionally valid as per Article 19(1)(a). Kedarnath Singh versus State of Bihar deliberated upon the constitutional validity of Section 124A of IPC. The Supreme Court held that any form of expression by an individual would be deemed seditious only when such expression tends to cause public disorder or disturb public peace. The court held Section 124A and Section 505 of IPC to be constitutionally valid, but within the bounds of this interpretation. Background: Kedarnath Singh was convicted for sedition and inciting public mischief because of his speech wherein he criticized members of the ruling party, then Congress. He appealed his conviction before the Supreme Court and challenged the constitutional validity of Section 124A as unreasonably violating Article 19(1)(a) of the Constitution of India. Legal issues involved. First, whether Sections 124A and 505 of IPC are constitutionally invalid as per Article 19(1)(a. And second, does Section 124A enact a law which is in the interest of public order and impose reasonable restrictions in the interest of public order? Arguments. Appellants argued that in a democratic setup, citizens should be entitled to criticize the government. In this regard, Section 124A of IPC affects the rights of citizens. Section 124A is ultra vires of the Constitution because it affects both kinds of speech, one which may disturb public order and the other which does not. Section 124A of IPC should be interpreted in light of the law of sedition in England, and hence only the speech which tends to disturb public order should be held liable under Section 124A. However, respondents were of the view that Section 124A is valid as the tendency of a speech to disturb public order is inherent in its interpretation, and the mere fact that some speech which does not disturb public order may be held liable under it. The judgment. The Honorable Court in this case quashed the sedition charges against Kedarnath Singh and stated that the remarks made by him were criticism of the government and cannot be termed seditious. Regarding the constitutional validity of Section 124A and Section 505 of IPC, the following observations were made. First, government established by law, as stated under Section 124A, is not synonymous with criticism of a specific party or person. Second, any form of expression by an individual would be deemed seditious only when such expression tends to cause public disorder or disturb public peace. Third, Section 124A and its interpretation were limited to include only such form of expression that incites or tends to incite public disorder. Fourth, the court held Section 124A to be constitutionally valid but within the bounds of its interpretation. And fifth, Section 505 of IPC was also held constitutionally valid by the court based upon the same reasoning. Importance and impact. The law of sedition in a democratic country needs to be drafted very carefully, as it can have an overarching effect on the free speech of citizens. The law of sedition is one of the most controversial provisions in Indian legislation. Many great freedom fighters were subjected to this law in British India. There was a strong demand to remove the law completely from independent India. However, it still exists in the statutes. The irony lies in the fact that the colonial masters, that was Britain, have removed the law of sedition from their books. Kedarnath Singh judgment is a landmark case which prevented the misuse of the provision of sedition in IPC to a great extent. However, the Supreme Court in this case did not consider Section 124A unconstitutional. Many claims challenging its validity are pending currently in the Supreme Court, and therefore it is very important to look forward to any developments made under it.